Today's case features a self-styled legal genius who decided to take his grievances all the way to Michigan's appellate court, not to challenge traffic laws, not to argue some fringe travel theory, but to argue that the state has no authority to hold him accountable for supporting his own children. That is the hill he chose.
I'm not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for that summary judgment, please.
You've asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
What makes this even more baffling is that he personally initiated the appeal after voluntarily asking the court to review his case. He then turns around and questions whether the very court he petitioned even has jurisdiction over him. That argument collapses immediately. Jurisdiction here is both personal and statutory, clearly grounded in state law and constitutional authority.
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kennar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this matter.
He tries to prop himself up by citing a federal case about civil rights claims not being dismissed without consideration. The problem is obvious. That principle does not magically convert every rejected filing into a civil rights violation. Losing motions does not equal constitutional abuse, no matter how confidently someone insists otherwise.
In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent of any contract with the state or Title 4D agency to give away my biological and genetic material.
Controlling law here is straightforward. Michigan statutes governing parentage explicitly authorize genetic testing, outline how it is conducted, and specify consequences for refusal. None of this is hidden. None of it is novel. It is written plainly into the law and has been enforced consistently for decades.
That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context, these are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, was this a constitutional court? The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements.
At this point, the real motivation becomes clear. This is not about legal theory or constitutional principle. This is about avoiding financial responsibility. The appeal reads less like a rights argument and more like an attempt to delay the inevitable confirmation of paternity and the obligations that follow.
I see that they're not here today, and that's some questions that raise, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers. 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test. And if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarm.
The statute he complains about actually provides full procedural transparency. It explains who can request testing, how samples are obtained, and what legal steps follow. There is no mystery here. The law does exactly what it says it does, and it does so with due process intact.
The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost. If I was going to be responsible, I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure.
Another familiar claim appears next. He insists he is not a corporation or legal entity subject to regulation. That argument has been rejected so many times it barely merits discussion. Courts do not treat biological parents as fictional entities to be opted out of responsibility by wordplay.
In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note contract to substantiate a debt or court claim. They did not. More documents I found. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation.
He also misunderstands how child support functions. Payments routed through the state are not the state buying private debt. The state acts as an administrator to ensure funds reach the child's legal guardian. It exists to enforce compliance, not to profit from parental neglect.
The main argument I have here and for you guys is full disclosure. It seems like they entered me in a contract without my consent, without full disclosure, and that's the problem here. I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22, and it's basically evidence they didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out
yes.
of time. We understand that you raise issues of disclosure,
Yes.
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief.
Mhm.
We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I will ask you to dismiss this without prejudice.
The court took the matter under advisement and indicated a written decision would follow. Once that decision becomes public, it will speak for itself. That's where this case stands for now. This has been Judge Talks. If you want continued coverage of courtroom decisions grounded in law and reality, stay tuned.